Gesellschaft mit beschränkter Haftung, German for company with limited liability, is a type of legal entity very common in Germany, Austria, Switzerland, and other German-speaking Central European countries. The name of the GmbH form emphasizes the fact that the owners of the entity are not personally liable for the company's debts. GmbHs are considered legal persons under German and Austrian law. Other variations include GmbH, and gGmbH for non-profit companies. The GmbH has become the most common corporation form in Germany, since the AG, the other major company form corresponding to a stock corporation, was until recently much more complicated to form and operate. History: the laws governing this type of legal entity were adopted in Germany in 1892, and in Austria in 1906. The concept of limited liability created by these laws inspired the legal establishment of the limited liability company form in other countries, although the concept of a limited liability company already existed in the United Kingdom. Requirements of formation: it is widely accepted that a GmbH is formed in 3 stages: the founding association, which is regarded as a private partnership with full liability of the founding partners' members; the founded company; and finally the fully registered GmbH. Only the registration of the company in the commercial register provides the GmbH with its full legal status. The Founding Act and the Articles of Association have to be notarized. The GmbH law outlines the minimum content of the Articles of Association, but it is quite common to have a wide range of additional rules in the articles. Under German law, the GmbH must have a minimum founding capital of 25,000, from which 12,500 have to be raised before registering in the commercial register. A supervisory board is required if the company has more than 500 employees, otherwise the company is run only by the managing directors who have unrestricted proxy for the company. The members acting collectively may restrict the powers of the managing directors by giving them binding orders. In most cases, the Articles of Association list the business activities for which the directors must obtain prior consent from the members. Under German law, a violation of these duties by a managing director will not affect the validity of a contract with a third party, but the GmbH may hold the managing director in question liable for damages. As of 2008, a derivate form called Gesellschaft or short UG was introduced. It does not require a minimum founding capital, and was introduced to assist company founders in setting up a new company. Also, the UG must accumulate 25% of its yearly earnings as legal reserve until it reaches 25,000. The owners may then decide to increase capital and rebrand to GmbH. Because a legal entity with liability limited to the contributed capital was regarded in the 19th century as something dangerous, German law has many restrictions unknown to common law systems. A number of business transactions have to be notarized, such as transfer of shares, issuing of stock, and amendments to the Articles of Association. Many of those measures have to be filed with the company registry where they are checked by special judges or other judicial officers. This can be a tiresome and time-consuming process, as in most cases the desired measures are legally valid only when entered into the registry. Because there is no central company registry in Germany but rather several hundred connected to regional courts, the administration of the law can be rather different between German states. Since 2007 there has been an internet-based central company register for the whole of Germany, called Unternehmensregister. Differences between GmbH in Germany, Austria, Switzerland and Liechtenstein, see also, Aktiengesellschaft, Gesellschaft mit Beschränkter, business organizations, corporation, THN Euro N Florin NNTH squared TH 3/4 NTH 3/4 TH 3/4 TH cubed N Euro TH degree TH 1/2 TH NTH micron TH 1/2 TH degree TH 3/4 TH cubed TH 3/4 TH squared TH 3/4 N Euro TH 1/2 TH 3/4 NN. Druid vs Agrania ena mod governo infinite u or, Druid 3/4 bar z homogeno od governostjo. II plus or minus I to the first II micron II plus or minus II micron II to the first II to the first I florin I 1/4 I 1/2 I 1/2 II, common die Gesellschaft of Aktien, Caller Tilt Fellelase copyright gar plus or minus tar RSASAG, limited liability company. THN Euro N Florin TH paragraph TH micron NNTH squared TH 3/4 NTH 3/4 TH cubed N Euro TH degree TH 1/2 TH NTH micron TH 1/2 TH degree TH 3/4 NTH cubed TH 3/4 TH squared TH 3/4 N Euro TH 1/2 TH 3/4 NN, Ru. TH plus or minus N per mil TH micron NNTH squared TH 3/4 NTH 3/4 TH cubed N Euro TH degree TH 1/2 TH NTH micron TH 1/2 TH 1/2 TH 3/4 TH to the first TH 3/4 NTH squared TH micron N on NTH squared TH micron TH 1/2 TH 1/2 TH 3/4 N and ON Zabidra bar Yerobia 3/4 O to Atbaldabu, Sociedad de Responsabilidad Limitada, Societal Responsabilita Limitada, Socia Copyright tar Copyright Responsabilita Copyright Limita Copyright E, Spolia Nostas Ruina Emomsna 1/2 M, Spa cubed Angstrom KZ Ogranikana Oddpowadzilnaya, TH 3/4 TH squared TH degree N Euro TH NN TH squared TH 3/4 TH TH 3/4 TH plus or minus TH 1/4 TH micron TH paragraph TH micron TH 1/2 TH 3/4 N TH squared N TH 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 3/4 TH squared N TH TH degree TH noeth 1/2 N. NN unshoka mi paruk jegjasi tar qfizo or, references. Further reading, Follin, Caroline. Chapter 4, The History of Corporate Ownership and Control in Germany. In Mork, Randall K.A. History of Corporate Governance Around the World, Family Business Groups to Professional Managers. University of Chicago Press ppA 223 Euro 282. ISBN A0-226-53680-7 Franks, Julian. Colin Mayer. Ownership and Control of German Corporations. The Review of Financial Studies 14, 943 Euro 977 doi, 10.109314.4.943 Tydrzycki, Introduction to the Serbian Law on Limited Liability Companies and Wero 2012, Volume 5, pages 140 to 144. External links, and Gesellschaft.